This is The Law Show on CL 650. Now back to the show.
I was wondering where that was coming from, and here we are with Lakes White, John Lakes and John White, our estate planning and litigators. We're talking about what we have, the theme from Family Feud as part of our music on the program this morning. It's a law show on CIL 650. Our guests, John Lakes and John White from Lakes White LLP in North Vancouver. We're talking about estates and wills and estate planning and something on the program today called joint tenancies. And this has just been brought up. We've just introduced it into the conversation. So I'm going to ask both of our guests, John Lakes and also John White, to talk more about joint tenancies, please, gentlemen, and tell us the advantages and also the disadvantages, if any, of entering into such an arrangement. Who wants to go first?
I'll go first. So the most common joint tenancies are between husband and wife. So the idea
is both your names are on the mortgage.
Yeah, let's say they've been married for 40 years. You know, they have everything together. So the house will be in joint names. All the bank accounts will be in joint names.
Sure.
Let's say the husband dies first. The wife files a death certificate. Everything goes to her. Normal circumstances.
Right.
That's the typical joint tenancy. Sometimes, let's say you own a house with your daughter, and you've each put 50% of the money into the house. You pay all the costs, and that could be a true joint tenancy as well, too.
Okay.
But what happens is some people create joint tenancies to either avoid probate or avoid other people's rights. And so the court has now got the right to intervene to determine whether something's a true joint tenancy or not, and in particular the Supreme Court of Canada.
Yeah, no, that's fair enough. There are obvious benefits to joint tenancies. The most obvious one is that it is simple.
Sure.
That is, if you and I own this water glass, which is sitting on the table here, jointly, and then I'm no longer around, what's changed? Well, now you own the water glass.
Right.
That's the concept of joint tenancy. That's the right of survivorship.
Sure.
Nothing really changes as far as your ownership goes. You always owned all of the water glass. You just used to own it with me, and now I'm not around, so now you just own it yourself.
Okay.
And that works out quite well in the example that John Lakes talked about with the 40-year marriage. But when you get into different scenarios, such as the parent putting his or her adult child on the title.
As was the example you used a few minutes ago.
As was the example I used a few minutes ago,
sure.
where no money changes hands.
Right. Dad just added the kids to the title.
Right. It's not like the child is buying an interest in the house.
Right.
They're just put on title to the house. And the plan was, in that other case, that the child would inherit and everything would go smoothly.
Sure.
But problems arise when only one child is put on the title to the house, which wasn't the case. Didn't happen in this particular case, but it happens in other cases where child number 1 gets put on title to the house, but child 2 and child 3 don't. And then after the parent passes away,
then you have the family feud.
Then you have your family feud. And the Supreme Court of Canada changed the law on this in a profound way about 8.5 years ago in a case called Pecor, where they changed the presumption that the court would apply in a scenario like what I described.
Okay.
It used to be that the presumption was that the adult child, that the parent rather, intended for the adult child to
inherit the house,
basically inherit it. But the Supreme Court of Canada reversed that presumption. So now the presumption is absent other evidence. That's an important point. But absent other evidence, the presumption is that the adult did not, or the deceased person did not necessarily intend for the adult child to own the house, and instead intended for his estate to own the house. And it's up to the adult child put on title for free to call evidence to show otherwise.
So if you're going to put your kids on title and do a joint tenancy on a piece of real estate or something, make sure you do it from the first day you do the deal. Otherwise, it's going to look a little shady down the road somewhere.
Well, and you got to be clear as to what you want to do as well. I mean, simply setting up an arrangement like that and not telling anybody about it, or not writing a letter or a document, a contract, something to explain what your intentions are, makes it a lot more difficult for the adult child to prove what the intention was, several years after the fact.
Yeah, John Lakes, you wanted to jump in on this?
But also there's some tax issues too.
I'm hoping you get to that
because
this is huge too.
Because let's say you and your wife own a house and you've owned it in North Van forever. You bought it for $100,000. It's now worth $1 million.
Yeah.
Technically, that is not subject to capital gains because it's your principal residence.
Right.
But if you'd put your daughter on title when you bought the house for $100,000, and it's now worth $1 million, and of course your daughter lives, in Bellingham, for example.
Right, okay.
So first of all, technically, her 1/3 interest could be subject to capital gains, and second of all,
because it's not her principal residence.
It's not her principal residence, and second of all, she's a non-resident too, which creates a taxation problem. So, for example, if you decide you and your wife want to sell the house and move into some care place,
right,
you may not have access to all those funds, and so the capital gains issue is an issue that people are more and more concerned about because CRA hasn't been that aggressive on it yet. But there's a whole pile of money, particularly in Greater Vancouver, that they could probably go after for residential homes, where people are trying to do this to defeat probate fees, which is only 1.4% of the value of the estate.
Right.
And all of a sudden they could be paying 22% capital gains instead, and I'd rather pay 1.4%.
Well, no kidding, huh? But this is really important stuff. I mean, this is very, very topical, and it's very, very now. We live in the most insanely priced real estate market in Canada. We are in the stratosphere, and it's, of course, as John Lakes just mentioned, it's been a huge boom for people who bought the house back in the 70s and the 80s for $50,000, let alone $100,000, and now it's worth $5 million, let alone $1 million.
We have a case which I'll just introduce, and John can take a little bit, but the person was so obsessed about paying probate fees is that they
wanted to avoid paying probate fees?
So what they did is they had a transfer signed before they died, and after they died, it was registered land titles to put the house in their name and their son's name as joint tenants, which avoid the capital gains, but thinking they could avoid probate, but it's created much more problems by doing that.
Well, it's created all sorts of messes, and is not helped by the fact that one of the beneficiaries in the will passed away not long after the woman whose estate we're looking at passed away, just within a matter of weeks. But it's again turned a situation which could have been simple. That is, this woman's assets could have gone through her will. They would have been distributed in various directions according to that will. And yes, there would have been a probate fee bill to pay. But at least it was fairly predictable what that bill would be.
Sure.
Instead, we're into new territory here. We've already had to commence one court proceeding on behalf of some infant beneficiaries, just to try and regularize the passing of the executor's accounts. And there are, I suspect, a number of other court proceedings which are going to be required simply to give effect to what this woman's intentions, I'm sure, were, which were simply to make sure that her estate went to her descendants.
Sure.
And it just gets messy.
Right. A couple of quick questions here before we take the break. One, probate. You use it a lot. It's part of what you do. It's a big part of your practice. Probate and the fees attached thereto, John Lakes, is what? Just the execution of a will. The fee you pay to have a will processed.
Well, no. Probate is the court recognizes the will and appoints someone the executor pursuant to the terms of will.
Okay. That process is called probate?
Probate.
Okay.
And there's a fee that's 1.4% of the estate. So for $1 million, it's $14,000. It's 98.6% of your estate, which is the same as your blood temperature.
Exactly.
Avoids probate.
Right.
And it's a fee that has to be paid, but I don't think it's the end of the world, personally.
Well, no kidding, 1.4%. And John White, the other question very quickly to you, sir, is, and you've identified this a couple of times in this conversation so far, the court had then to reconstruct the intentions of the person who died. You are in a business in which the most valuable witness is never present and never available. That makes your job incredibly challenging.
Well, it sure can. There are all sorts of wills type legal actions that require us one way or the other to reconstruct what the intention of the deceased might be, and depending on what type of case it is, different sorts of evidence can be brought in. But these joint tenancy cases are a great example,
right,
where there are, if you can find a document that dates from around the time that the adult child was put on title, that is a document coming from the witness who's no longer around, that's pretty valuable. That tells us a lot about what this person was thinking at the time.
And fewer big gaps to fill in out of your imagination, almost.
Right. And the court has relaxed its ban on what we call hearsay evidence,
right,
for documents like that. On the other hand, you get a letter written 10 years later after there's been a divorce. And you have the adult looking back and saying, well, this is what I meant to do 10 years ago and I just didn't tell anybody about it. That's not particularly valuable. That doesn't tell us a lot about what this person's intention actually was 10 years ago.
Right.
It's more what they would like their intention to have been today.
All right. Interesting challenges for both John Lakes and John White. The firm is Lakes White LLP. We're talking North Van here, folks. And we're back with lots more on The Law Show after this quick timeout.
There's more of the show still ahead. This is The Law Show on CL 650.